Welcome to our Regulation Mastery session. In this session, we will continue reading the CSSF Circular 22-806 from Part 1 Outsourcing Arrangements, Chapter 4. Governance of Outsourcing Arrangements. Subsection 4.3.2.1 Sub-outsourcing. 78. The outsourcing agreement shall specify whether or not sub-outsourcing, in particular of critical or important functions, or material parts thereof, is permitted. 79. If sub-outsourcing of critical or important functions is permitted, in-scope entities shall determine whether the part of the function to be sub-outsourced is, as such, critical or important, i.e. a material part of the critical or important function, and if so, record it in the register. 80. If sub-outsourcing of critical or important functions, or material parts thereof, is permitted, the written outsourcing agreement shall a. Specify any types of activities that are excluded from sub-outsourcing. b. Specify the conditions to be complied with in the case of sub-outsourcing. c. Specify that the service provider is obliged to oversee those services that it has subcontracted to ensure that all contractual obligations between the service provider and the in-scope entity are continuously met. d. Require the service provider to obtain prior specific or general written authorization from the in-scope entity before sub-outsourcing data. e. Include an obligation of the service provider to inform the in-scope entity of any planned sub-outsourcing or material changes thereof, in particular where that might affect the ability of the service provider to meet its responsibilities under the outsourcing agreement. This includes planned significant changes of subcontractors and to the notification period. In particular, the notification period to be set shall allow the in-scope entity at least to carry out a risk assessment of the proposed changes and to object to changes before the planned sub-outsourcing, or material changes thereof, come into effect. f. Ensure, where appropriate, that the in-scope entity has the right to object to intended sub-outsourcing, or material changes thereof, or that explicit approval is required. g. Ensure that the in-scope entity has the contractual right to terminate the agreement in the case of undue sub-outsourcing, e.g. where the sub-outsourcing materially increases the risks for the in-scope entity, or where the service provider sub-outsources without notifying the in-scope entity. 81. In-scope entities shall agree to sub-outsourcing critical or important functions, or material parts thereof, only if the subcontractor undertakes to a. Comply with applicable laws, regulatory requirements and contractual obligations, and b. Grant the in-scope entity and competent authority the same contractual rights of access and audit as those granted by the service provider. 82. In-scope entities shall ensure that the service provider appropriately oversees the subcontractors, in line with the policy defined by the in-scope entity. If the sub-outsourcing proposed could have material adverse effects on the outsourcing arrangement of a critical or important function, or would lead to a material increase of risk, including where the conditions in point 81 above would not be met, the in-scope entity shall exercise its right to object to the sub-outsourcing, if such a right was agreed, and or terminate the contract. Subsection 4.3.2.2 Security of Data and Systems. 83. The confidentiality and integrity of data and systems shall be controlled throughout the outsourcing chain. In particular, access to data and systems shall fulfill the principles of need to know and least privilege, i.e. access shall only be granted to persons whose functions so require, for a specific purpose, and their privileges shall be limited to the strict necessary minimum to exercise their functions. 84. In-scope entities shall ensure that service providers, where relevant, comply with appropriate ICT security standards. 85. Where relevant, e.g. in the context of cloud or other ICT outsourcing, in-scope entities shall define data and system security requirements within the outsourcing agreement and monitor compliance with these requirements on an ongoing basis. Where, in the outsourcing agreement, security measures are made available by the service provider to the in-scope entities for personalized selection and configuration, notably for cloud outsourcing, in-scope entities shall ensure that proper selection and configuration take place, in line with the in-scope entity's security policy and requirements. 86. In the case of outsourcing to cloud service providers and other outsourcing arrangements that involve the handling or transfer of personal or confidential data, in-scope entities shall adopt a risk-based approach to data storage and data processing locations, i.e. country or region, which shall in particular take into account point 101c, d and e and information security considerations, and comply with the provisions of points 133 to 143. 87. Without prejudice to the requirements under GDPR, in-scope entities, when outsourcing, in particular to third countries, shall take into account differences in national provisions regarding the protection of data. In-scope entities shall ensure that the outsourcing agreement includes the obligation that the service provider protects confidential, personal, or otherwise sensitive information and complies with all legal requirements regarding the protection of data that apply to the in-scope entity, e.g. the protection of personal data, and that banking secrecy or similar legal confidentiality duties with respect to clients' information, where applicable, are observed.